I'm Bob Orr, a retired North Carolina Supreme Court Justice. Let me begin by thanking you for your time and interest in joining us for the first Convention on Founding Principles. I'd like to talk briefly with you about one of those critically important principles, the need for an independent judiciary. We all tend to agree that judges need to be independent. Unfortunately, while both sides of America's vast political divide are happy to pay lip service to this concept, yet in their self-interest, partisans really want the judiciary stacked with judges and justices that tend to favor their political or ideological perspective. Nowhere is this more evident than in the process of appointing and confirming federal judges. One of the most egregious examples of the high-stakes politics played with federal judicial appointments came in 2016 after the untimely death of U.S. Supreme Court Justice Antonin Scalia. President Obama, on March 16, pursuant to the Constitution, nominated Chief Judge Merrick Garland, an experienced, well-respected member of the United States Court of Appeals for the District of Columbia. Like all other presidential nominations to the federal courts, the Constitution requires the advice and consent of the Senate. Historically and by long-standing practice, the term advise and consent means a confirmation process. This process has meant investigations into the qualifications of the nominee, testimony before the Senate Judiciary Committee, and ultimately a vote by the full Senate on the confirmation or rejection of the nominee. Instead of following this historical process, Senate Majority Leader Mitch McConnell steadfastly refused to allow the nomination of Judge Garland to come forward for a confirmation hearing and subsequent vote by the Senate. This action by McConnell was a flagrant abuse of power. There was no reasoned basis for denying Judge Garland a hearing and a vote, except McConnell and his Republican colleagues did not want an Obama nominee to get the vacant seat on the Supreme Court. Instead, McConnell's actions evidenced the very basest political motive, one grounded in a partisan mindset to block the nomination by a Democratic president, hoping that a Republican would become president after the 2016 election. McConnell and his allies were banking on a new president who would send forward partisan loyalists to fill any and all vacancies on the U.S. Supreme Court and other federal courts, not with women and men pledged to the independence of the judiciary and abiding by the Constitution and laws of our country, but instead judges and justices who could be counted on to rubber stamp the acts of the president and the Republican majority. Mitch McConnell got his wish. With the election of Donald Trump in 2016, the push for the appointment of lockstep conservative judges and justices across the entire federal judiciary took shape regardless of qualifications and experience. Trump's view of these appointments was not to fill vacancies to the federal bench with independent-minded jurists, but instead to name individuals who would merely be an extension of his presidency and his objectives. Trump expected his appointments to the judiciary to be loyal servants, compliant with his dictates and actions in their rulings and decisions from the bench. The entire foundational concept of an independent federal judiciary was neither understood nor desired by the new president, and Mitch McConnell and the Senate Republicans were more than happy to roll over and comply with Trump's demands. The specific beneficiary of Mitch McConnell's inaction was Judge Neil Gorsuch, nominated by Donald Trump for the still vacant seat on the Supreme Court. Judge Gorsuch got his hearing before the Senate Judiciary Committee and the confirmation vote by the Senate putting him on the Supreme Court. Conservative partisans cheered the result. But in addressing the Senate Judiciary Committee, Judge Gorsuch articulated foundational principles and the need for an independent judiciary that he believed defined service on the court. Referencing the judicial figures who had been mentors to him, Judge Gorsuch stated, "By their example, these judges taught me about the rule of law and the importance of an independent judiciary. How hard our forebears worked to win these things, how easy they are to lose. How each generation must either take its turn carrying the baton or watch it fall." He went on to add, "My decisions have never reflected a judgment about the people before me, only a judgment about the law and the facts at issue in each particular case. A good judge can promise no more than that, and a good judge should guarantee no less. For a judge who likes every outcome he reaches is probably a pretty bad judge, stretching for policy results he prefers rather than those the law compels." Unfortunately, the cynics on the left didn't believe nor want to believe that Judge Gorsuch was sincerely and honestly reflecting his philosophy of being a judge. The cynics on the right arguably winked and nodded, feeling confident that Judge Gorsuch didn't really mean what he said and would be a reliable vote for their agenda. During this past term of the Supreme Court, national attention is focused on a series of cases in which Judge Gorsuch, Chief Justice Roberts, and Justice Kavanaugh, the other Trump nominee to the Supreme Court, have voted against the position advocated for by conservatives and President Trump. In the case of Bostock versus Clayton County, Georgia, which addressed the applicability of the Civil Rights Act of 1964 to discrimination based on sexual orientation and gender identity, the majority opinion was written by none other than Justice Gorsuch. Immediately, the partisans on the right began criticizing him. A writer for the American Conservative lamented about Judge Gorsuch's opinion, "The demoralization of social conservatives is profound." Even more recently, Vice President Pence was quoted as saying how disappointed conservatives are in Chief Justice Roberts. Disappointed because he hasn't towed the ideological line advocated by the party faithful in every case. This damaging perspective of judges and justices being nothing more than political pawns in the war between partisan and ideological opponents must end. Such a view undermines the necessary independence of the judiciary, taints nominees to the bench with a partisan brush, and undermines the public's confidence in the impartial decision-making of our courts. Meeting ideological litmus tests in order to be nominated and confirmed, and then viewing decisions made by these jurists within the partisan framework serve ultimately to only undermine the very legitimacy of our courts. I fervently hope that the next President of the United States will heed those warnings. And make no mistake about it, I hope that the next president will be Joe Biden, not Donald Trump. Having been a registered Republican for 45 years, and having been elected 4 times to statewide judicial office as a Republican, I take my decision to support and vote for Joe Biden seriously. But I have confidence in Joe Biden's commitment to the constitutional principles that we stand for and the rule of law. I have no confidence that Donald Trump can move beyond his disregard and disdain for the rule of law and the constitutional underpinnings of our democracy, including the independence of our judiciary. As we stand here on the brink of a national election, we are faced with a sitting president intent on grabbing and consolidating any and every power of government that he can get away with. Unfortunately, Congress has failed to adequately rein in this despotic assertion of executive power and privilege. As envisioned by our founders, an independent judiciary devoid of partisanship and devoted to the constitutional rule of law stands as the last great constitutional restraint against such despotism. The responsibility falls on us to protect and defend that principle from those who would tear down our democratic foundations. We must not fail.